Welcome, everyone, and thank you for joining us for this latest episode of LawCats Live. My name is Andrew Cohen. I am the Associate Dean for Research and Professor of Law at the James E. Rogers College of Law. I also direct the Rehnquist Center for the Constitutional Structures of Government. My fellow panelists today are Professor Albertina Antonini and Professor Barbara Atwood, as well as 3L at the law school, Nate Goodman. And we're delighted that you could join us for this panel today on the landmark case of Bostock versus Clayton County, just handed down by the United States Supreme Court. This case, as many of you will know, interprets Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination on the basis of sex, to prohibit employment discrimination on the basis of sexual orientation and transgender status, on the theory that this discrimination represents a subset of discrimination on the basis of sex. The Q&A will take place after the panelists are finished presenting. However, at any point during their presentations, if you have a question, you should feel free to please submit it through the Q&A function at the bottom of your Zoom screen. This webinar will be recorded and posted at a future date on our Arizona Law website. Please remember to check the master calendar for upcoming LawCats live events. And with that, I will turn the floor over to Professor Antonini.
Great, thanks so much, Professor Cohen. So I will kick off our discussion by introducing you to the parties, the three individuals who were fired and who, by contesting their firing, made this case possible. I'll also briefly set out the state of Title VII jurisprudence coming into Bostock. The specific and individual stories of the litigants are often lost in the more general abstractions of the cases and the legal rules that emerge. Justice Gorsuch begins the opinion by noting, few facts are needed to appreciate the legal question we face. But the law is made up of people who bring their cases to court. This is especially true in employment matters, given that enforcing legal prohibitions against discrimination or harassment depends on the individuals who suffered an adverse employment action to pursue and litigate their cases. So these facts are worth excavating, both to appreciate what is at stake here and to see how these individuals relied on the law as a tool to allow them to continue to work, to gain an income, to occupy jobs they loved, and to be able to do so without hiding who they are. So on this slide before you, we have the three plaintiffs. So Amy Stevens, on your left, was born in 1960 in North Carolina. She knew herself to be female for most of her life, even though she was born biologically male. In 2009, she said as much to her wife, Donna, and for a brief period, she tried to live as a woman at home and as a man at work. And she was working as a funeral director for Harris Funeral Homes in suburban Detroit. But in 2013, Amy decided to undergo gender transition, and she wrote a heartfelt letter to her colleagues asking for empathy and support as she began the process. She was fired 2 weeks after she sent her letter. So she filed a charge with the EEOC, the Equal Employment Opportunity Commission, which investigates complaints based on workplace discrimination. Her claim was that she was being discriminated against on the basis of her sex. She first brought her case in 2013, 7 years before the Supreme Court would issue its decision. Next in the middle here, we have Donald Zarda. Donald was a skydiving tandem jump instructor at Skydive Long Island in Calverton, New York. In the summer of 2010, he was doing a tandem jump for a woman and her boyfriend. And to put her at ease, given that they were going to be strapped to each other during the jump, he says that he told her not to worry, that he was, quote, 100% gay. The woman, however, felt uncomfortable and accused him of acting inappropriately. He was fired shortly thereafter, and the company has since then given different explanations for the reasons why. He became very depressed. He wanted to clear his name from this incident, and he wanted to be able to get a job and make money. So during this time, he began seeking bigger and bolder adrenaline rushes and even bought a wingsuit, which lets you float or fly in the air for a few minutes before dropping from a higher altitude. He also took up base jumping, where you jump off of fixed objects like buildings. Donald was fired in 2010, 10 years ago. Then we have Gerald Bostock, who is a child welfare advocate for the juvenile court in Clayton County, Georgia. He worked for the county for a decade, helping abused and neglected youth through a program known as CASA. He was a stellar worker, receiving positive performance reviews, and was even awarded Employee of the Year. In 2013, he decided to join a gay softball team with the Hotlanta Softball League. Gerald explained that soon after, complaints were raised about him and his sexual orientation. He was eventually fired. And at the time, he was recovering from prostate cancer, and the loss of his job meant that he also lost his health insurance. 2 out of the 3 plaintiffs did not live to see their rights vindicated. Amy Stevens died in May, 2 months ago, from kidney failure, and Donald Zarda died in 2014, base jumping off a cliff in Switzerland at the age of 44. Now, beyond these 3 plaintiffs, there were many, many people who were involved in these cases and who supported the cause, from attorneys who represented each of these clients, to attorneys who submitted hundreds of amicus briefs on different legal issues and the ramifications of the decision here, to LGBTQ activists, to law professors who wrote about these issues, to the EEOC, to the oralists who argued the cases before the Supreme Court. There were a total of over 200 filings made throughout the course of litigation, which Nate was a part of and which he will address for us. So the litigants had to be very clear about which arguments they thought might persuade a majority of the justices. They decided to present a textualist argument based on the words used in the statute and incorporated a but-for standard of causation, which both Nate and Professor Atwood will discuss further, given that that is what the majority ultimately adopted. So going into the Supreme Court, federal appellate courts in each of these 3 plaintiffs' cases has held that Title VII covered discrimination on the basis of gender identity in the case of Amy Stevens, and also sexual orientation in the case of Donald Zarda. One court, however, held that it did not cover sexual orientation in the case of Gerald Bostock. So the issue squarely presented the court in this case is whether Title VII's language, which is reproduced in the following slide, that prohibits discrimination in employment because of the individual's sex, includes sexual orientation and transgender status. So from the moment that Title VII was enacted, what sex encompassed was contested. For example, in General Electric Co. versus Gilbert, decided in 1976, the Supreme Court held that pregnancy discrimination did not constitute discrimination because of sex, because pregnancy discrimination doesn't only discriminate against women, given that not only can men not be pregnant, but also some women at certain times are also not pregnant. Courts similarly rejected early sexual harassment claims, saying it was not discrimination based on sex, given that not all members of a particular class were targeted. But in 1978, Congress passed the Pregnancy Discrimination Act, specifically defining discrimination on the basis of pregnancy to be discrimination because of sex in Title VII. And the Supreme Court, since those early cases, has held that sexual harassment is discrimination because of sex. So a similar question that emerges in the cases involving sexual orientation and transgender identity is, how can there be discrimination on the basis of sex if the discrimination encompasses both men and women? That is, discrimination on the basis of sex might be hard to understand if both men and women are discriminated against, meaning that the category includes gay men, lesbian women, transgender men, and women. So one response that emerged in the Title VII jurisprudence is the finding that sex stereotyping constitutes discrimination because of sex. The basic idea is that Title VII prevents discrimination against individuals for failing to conform with stereotypes about their sex. What does this mean? If, for instance, a woman acts too much like a man in a way unbecoming of a woman and is fired for that, then that is discrimination because of sex. And in 1989, the Supreme Court held in Pricewaterhouse versus Hopkins that an employer cannot deny employment opportunities to a woman based on, quote, stereotypical notions about women's proper deportment. So under this understanding of sex discrimination, discrimination on the basis of transgender status is a type of sex stereotyping. The idea is that an employer cannot target someone for being perceived to be an, quote, insufficiently masculine man, an insufficiently feminine woman, or an inherently gender nonconforming individual. The anti-stereotyping principle also prevents employers from enforcing stereotypes about who men and women should be with. Discrimination based on sexual orientation is sex stereotyping in that it is based on ideas of who someone should partner with based on that individual's sex. So sex stereotyping wasn't ultimately the main basis for the court's holding, but the court does seem to affirm the case that enshrined this reasoning Price Waterhouse, and Justice Gorsuch's opinion itself raises problems when an employer engages in sex stereotyping. So I will now let Professor Atwood get into the court's actual holding and its reasoning.
Thank you very much. It's great to be able to talk about this decision. It's a blockbuster decision by any measure. What I'm going to do is explain the reasoning of Justice Gorsuch's opinion, the majority opinion, and there were no concurrences, so he is speaking for 6 justices. And in particular, I'm going to focus on the sharp disagreement between him and the dissenters about how to read a federal statute, how to read statutes. And everyone is a textualist these days, it seems. Justice Gorsuch in particular wants to be known as a textualist. He succeeded the late Antonin Scalia on the Supreme Court. Justice Scalia, of course, is the person who really made textualism and originalism a household word kind of into public awareness in this country. So you can keep that in mind in terms of who is doing the best job of interpreting a statute as I talk about the opinion. A couple of preliminary points, or actually 4 preliminary points that are pivotal to the decision. One is that the employers admitted that they had intended to discriminate on the basis of sexual orientation or transgender status. There were no ambiguities, and that brought up the issues very cleanly. Second, Justice Gorsuch didn't really need to get into some of the nuances that Professor Antonini was talking about. He said, for this case, we don't need to go further than to say sex means biological distinctions between male and female. We can resolve it quite simply, taking that as the meaning of the statutory term. He also explained the meaning of Title VII's language, discrimination because of sex. He said it requires a plaintiff to show that a particular outcome would not have happened but for the employee's sex. And he made clear that it doesn't matter that there may have been other factors that contributed, other biases, as long as sex was a but-for cause, as long as if you change the sex of the employee, the decision would have been different, then you've satisfied Title VII. Finally, he says throughout the opinion that discrimination under Title VII is really an individually focused inquiry, not a group-based inquiry. And that's raised some questions, what that might portend for the future. But his goal, I think, there was to respond to the employer's arguments that they were, you might say, equal opportunity discriminators. Gay men and gay women across the board were not accepted into the workforce. Justice Gorsuch says, just because you treat those groups equally, the individual has experienced sex discrimination, and that's what is going to be our focus. Some employment law lawyers think that the clarification of the but-for cause analysis is actually extremely important and may be almost as important as the core holding. Turning to the core holding, Justice Gorsuch says, as quoted on the slide, that Title VII's message for the world is simple and momentous. Right preceding the quoted material, he says an individual employee's sex isn't relevant to the selection, evaluation, or compensation of employees. That is the message of saying no discrimination on the basis of sex. He says, it's equally simple and momentous for these cases that an individual's homosexuality or transgender status is not relevant to employment decisions. And he says that's because it's impossible to discriminate against a person based on sexual orientation or transgender status without discriminating on the basis of sex. He was persuaded by some simple logic that was put forth in the briefs in the case and argued during the oral argument. By the way, one of the advocates in the case, David Cole, who's the National Legal Director for the ACLU, represented Amy Stevens, is our McCormick Society speaker for the fall on September 14th. And if you go to our master calendar and want to view him, it will be a virtual presentation. Should be a very exciting program. Gorsuch makes his case, makes the logic clear through some simple hypotheticals. He says, take two similarly qualified employees, both of whom are attracted to men. If one is a man and one is a woman, and the employer fires the man because he's attracted to men, he has discriminated against him based in part on his sex. If you changed his sex, the outcome would be different. And he says, likewise, consider a case where an employer has two similarly qualified employees, both presenting as women, but one of them was identified as male at birth. If the employer fires the transgender woman, the employer is penalizing that individual for traits or actions it tolerates in the employee identified as female at birth. In other words, he's saying that that discrimination based on sexual orientation or transgender status is inextricably bound up with sex. The tone of the decision is one of self-proclaimed judicial objectivity. He's saying, I'm just giving the words their plain meaning. I'm not going out on a limb, and I'm not being an activist judge. That's, if you read the decision, you get that message loud and clear. Let me turn briefly to some of the major defenses that were raised in the case. The employer said plaintiffs were fired because they were gay or transgender, not because they were male or female. They did not intend to discriminate on the basis of sex, the employers argued. And in fact, the employees themselves, when they referred to what had happened to them in the case, they said, yeah, I was fired because I was gay. I was fired because I was transgender. People didn't dispute that. But the court goes back to its prior reasoning. If they were fired because of those reasons, it is inextricably tied up with sex. And Justice Gorsuch says it doesn't matter if the employer didn't even know of the sex of the employee, as long as discrimination based on sexual orientation or transgender status was a factor. The employers pointed to history, said Congress could not have possibly intended this result back in 1964. And they said there have been bills on a regular basis introduced into Congress over the years to expand Title VII to include sexual orientation, discrimination, and transgender status, and those have failed. Therefore, this is something that's going to be inconsistent with legislative intent. A couple of responses to that, actually. One is a textualist response. Justice Gorsuch says, look, the statute's clear, there's no ambiguity. Therefore, we don't have a basis for looking behind the words of the statute to legislative intent. That's kind of a truism in textualism itself. So we're bound by the words of the statute. But he also said, even in 1964, if the addition of sex to Title VII was a poison pill, which is one of the sort of stories of Title VII based on the introduction by Congressman Howard Smith, maybe wanted to just sort of gut the whole Civil Rights Act. Even if that were the case, Congress understood, we know from research that Congress understood that this was a very broad term to include sex within the prohibited categories in Title VII. Some people thought it would undermine traditional gender roles. And so it wasn't as if people weren't aware of the broad, potentially very broad scope of the term sex. And he says, in his passage that I found quite telling in his opinion, he says, if we can't bind ourselves to what would be the popular understanding of this term, this would tilt the scales of justice, he wrote, in favor of the strong or popular and neglect the promise that all persons are entitled to the benefit of the law's terms. As with respect to the fact that there had been repeated bills introduced in Congress that were unsuccessful, he says, look, we can't interpret Title VII in 1964 based on what Congress hasn't done over the years after that. That would be entirely speculative. And if you lose, as you learn in law school, if the law and the facts are against you, then you can argue policy. And here the employers and indeed the dissenters argued that this interpretation would give rise to disruption, social upheaval, the bathrooms argument, the high school sports, the locker rooms, religious freedom. And Justice Gorsuch says, we are not free as judges to refuse, to reject a plain interpretation of this language based on what we fear might happen. And those questions are not before us in any event. And so he turned that kind of argument against them to expound on the role of the court. And he basically is saying, we as judges have to give the plain interpretation that we find in the statute. We can't avoid it because of what we think is best for society. He says that's left to the legislative branch. Judicial humility should make us refrain from adding to or diminishing the plain meaning of a statute. The dissenters made many of the same arguments that the employers made, but let me just focus on the textualist point. And Justice Alito, whom Justice Thomas joined in dissent, disagrees sharply with Justice Gorsuch's approach to statutory interpretation. And he starts towards the beginning of the opinion. He says, the court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated. And that would be an interpretation that would bring a statute in line with contemporary norms. That's what he's accusing Justice Alito and his colleagues of doing. Both Justices Alito and Justice Kavanaugh it disputed this textualist approach. And one thing they agree on is that we should look at terms within their social context. What did Congress understand these words to mean? Not so much looking back to legislative history, but let's give it an interpretation in context. And he says here, in context, they could not have meant the result that is being attained today. So they could not have meant that. And Justice Alito cites to numerous examples to prove his point of accepted discrimination against people based on sexual orientation, and indeed criminalization of homosexual conduct across the United States in the mid-1960s. Justice Alito hurls some pretty tough adjectives at the majority. He says this is going to bring about a disruption in society. It will violate privacy. It will violate religious freedom. And he talks about the opinion as breathtakingly arrogant, indefensible, irresponsible, radical, and jaw-dropping. Justice Kavanaugh dissented separately, I think partly not to be associated with the vehemence of Justice Alito's words, but he agreed on the central point that he thinks the court has usurped the role of Congress and that this was really a question of who decides. Even if we all agree that the end result is good, who decides? And he thinks the court mistakenly went ahead with its activist decision. So I'm going to turn it now to our law student 3L, Nate Goodman, who can talk about the strategic advocacy that he was involved in. And I think it's just a really wonderful example of sort of strategy at work. Nate.
Thank you, Professor, for that introduction. Yes, as the professor said, Nate Goodman, I'm a rising 3L. Last summer, I had the pleasure of working for an organization called Freedom for All Americans. It's a bipartisan organization that works to bring about full equality for the LGBTQ community. It is mainly oriented towards policy work, so getting non-discrimination bills passed at the state, local, and federal level. However, the supervisor that I was working with was the consolidator of the amicus briefing in favor of the plaintiffs. So he was in charge of making sure that we had all the subjects that we wanted to get down. Certain firms were assigned to the amicus writers. And essentially, because this was a statutory interpretation case strictly, we really wanted to focus on pulling some of the conservative justices onto our side, because obviously you need a 5-person majority in order to have law. So really I conducted research and wrote memos regarding Chief Justice Roberts, Kavanaugh, and Gorsuch, kind of analyzing how they had conducted statutory interpretation in the past. And I'll just focus mainly on Justice Gorsuch because he was the one who wrote the opinion. But essentially, from the research that I found, it kind of almost lines up a little bit. He held true to his very textualist approach that he had conducted previously on the 10th Circuit, as well as his brief stint on the Supreme Court as well. As Professor Atwood stated, he's bound by the text. That is, he has always professed that the text as it is what he is bound by. And scholars have kind of coined the way Gorsuch has conducted statutory interpretation as a textualist 3.0. So kind of like a new textualism, where he's very concerned with notice and how would an ordinary person understand these words to mean and put them on notice regarding their obligations under the law. So that's kind of just kind of a quick synopsis of what I had found and the kind of memo that I prepared. So these memos were sent to the amicus writers. Because impact litigation, there's always so many parties involved, and especially with a landmark case like this, it was shared with amicus writers who were specifically geared towards writing explicitly regarding textualism and how, because of sex, can and should be interpreted to include sexual orientation and gender identity, and it wouldn't be judicial activism or usurping the role of Congress in finding such an interpretation. And luckily, our strategy came out on top. We're very thankful that it came out the way it did, and it's interesting because I had put the memo away after I had sent it to my supervisor, and got feedback on it, and I just pulled it up, and it's just interesting to see how his form of statutory interpretation is consistent all the way through. It was just a really great experience working through that over the summer, and really excited to see the outcome and how it could have positive ramifications in the future as well.
Thanks very much to all of our panelists for those terrific presentations. We'll now spend the balance of our time on Q&A. It's 12:45 now, and we'll go till noon until 1 o'clock. And we have several questions already, and anyone else who has questions should please feel free to type them into the Q&A, and I will present them to the panelists. Our first question is, what does this case tell us about the court's future civil rights jurisprudence? Do we know what issue will be the next legal battle likely to make it to the court? Professor Atwood,
Yeah, I think one of the big issues that people are concerned about is the degree to which the court's jurisprudence on religious freedom will intersect with and be in tension with this sort of decision. And that's, I mean, this court, this term has decided a few religious freedom cases that have given rise to this concern among civil rights lawyers that we haven't yet seen a case where in the US Supreme Court where religious freedom is inconsistent with a employment discrimination equality law, and whether the court's going to view religious freedom as in fact trumping the command of equality in other civil rights litigation. I have no reason to think the court will take that position. Its religious freedom cases have been in very different circumstances with respect to, for example, religious employees. In a case that was decided this term, a religious institution is free to fire an employee who qualifies as a ministerial employee. This was a case called Our Sister of Guadalupe involving religious schools. And the court gave a quite broad definition to ministerial exemption to the extent that, I mean, that's going to be an issue, but that right now is limited to religious institutions. When you move into the secular world, I think that those concerns are going to be perhaps voiced, but I'm quite hopeful that equality law will trump those concerns. But my fellow panelists may have different views, and I think that Nate actually was asked to do some research on this very point.
Yeah.
Nate, would you like to weigh in?
Sure. I mean, I'll just kind of give a background of the research I did and try to answer the question as best I can. But I additionally did research on the Free Exercise Clause and Religious Freedom Restoration Act, better known as RFRA, because at the Sixth Circuit in the Stevens case, the employer did raise a religious objection under RFRA. The court did not find in favor of that argument. However, on appeal, the employer did not raise the issue again, so it was waived. But it kind of raised a red flag for the LGBTQ community that this could be coming down the pipeline. So my supervisor wanted me to do some research on it. And regarding the Free Exercise Clause and RFRA, and professors, you can weigh in a bit more on more of the substantial law, but in order for someone to have a valid claim under the Free Exercise Clause, if there's a law of general applicability that is evenly distributed and evenly, sort of looking for, can't think of the word, evenly distributed, not based on, it's not slighted towards religion, then the law stands as there was no free exercise violation. And then under RFRA, if a law substantially violates someone's religious belief and religious practices, then that would be a violation of RFRA, and there would have to be a religious exemption regarding that law or non-discrimination law. So I can't speak too much because it's a lot of hypothesizing, and we're not entirely sure where it goes. But I mean, we do know that the court, as it stands now, is very attentive to religious rights. And so finding that balance between civil rights and religion is something that I think we definitely have our eyes on, and something that I as personally have been very considerate of and very interested in. And I mean, I can't speak too much, and I would love to hear what Professor Antonini has to say as well, but yeah.
Thank you. Yeah, it's always fraught, I think, to predict what are the future cases that will take place. But I will say that, as has been mentioned by Nate and Professor Atwood, Justice Gorsuch ends the opinion by stating explicitly that this case does not address the Religious Freedom Restoration Act. And Justice Gorsuch labels it in this opinion to be a super statute, which she explains displaces the normal operation of other federal laws, like Title VII, and this is on page 32 of the opinion. Some other civil issues that might come up are actually outlined relatively helpfully by Justice Alito's dissent. Justice Alito has a list of potential impacts on different areas that might now be affected by the Bostock decision. So Justice Alito, for example, talks about bathrooms and locker rooms and how they might be laws regulating bathrooms and locker rooms, and in particular Title IX, which prohibits schools that receive federal funding from discriminating on the basis of sex, might be affected by this interpretation of what because of sex means. Sports, housing, employment by religious organizations, which we've touched on, freedom of speech, and other constitutional claims. There might, for instance, be a heightened standard of review that now applies to sex and gender minorities like it does to discrimination based on sex. So there are a number of potential issues in the pipeline. And I will just say that the current administration is also creating issues, right? So for instance, a few days before the decision in Bostock was issued, the Trump administration revoked an Obama administration rule that had interpreted the Affordable Care Act's sex discrimination provision to prevent discrimination based on sex stereotyping, gender identity, and sexual orientation. So we now see issues coming up not only because of the court's decision, but also the Trump administration's way of interpreting what because of sex actually includes.
And let me just, as a postscript to that, note that there are several lawsuits challenging that very change by the Trump administration. 22 state attorneys general have joined in a lawsuit arguing that based on Bostock, in part, that the prohibition about sex discrimination in the Affordable Care Act has to be extended to discrimination on the basis of sexual orientation and transgender status, which was essentially the approach that the Obama administration took. They also are arguing that it was an arbitrary and capricious change in the regulation. But there are, that when you ask about the future of civil rights litigation, I think Bostock will spawn a lot of arguments because we have over 100 federal statutes that prohibit discrimination on the basis of sex. And so Bostock gives new energy to arguments that those prohibitions should be given the same kind of expansive interpretation.
I will also say really quick, going off of what Professor Atwood said, Bostock is a huge victory because in regards to what Anthony was saying as well, Title VII and Title IX have actually been known to be interpreted along the same lines. They have kind of the same statutory history. So it is positive in the bathroom front, in school sports fronts, and we're already seeing the positive ramifications coming from it as well. On the 11th Circuit, there is a case, Adams v. Board School of St. John's, that is a case regarding a transgender student who wanted to use a bathroom in conformity with their gender identity. So there was supplemental briefing on that right after Bostock. So it makes the counter argument difficult when you have such a landmark decision like this. So just the positive ramifications that are coming from it, not only on the Title VII front, but on these other fronts as well. It's a huge leg up, as Professor Atwood was kind of mentioning.
Thank you all. Our next questioner notes that Congress previously rejected several proposed amendments to include sexual orientation and gender identity in Title VII, and wonders whether that should be relevant to the statutory interpretation questions posed by this decision. And I might add a follow-up question of my own, which is, why doesn't that matter to Justice Gorsuch? Because I think this is a signature feature of the textualist approach that he brings to this case. Nate, would you like to take the first crack at this?
Sure, I'll take a little bit of it. So from a textualist point of view, again, Gorsuch's hands are tied to the text. A textualist normally turns to kind of statutory history or legislative history when the text is ambiguous. In this case, however, he clearly states rightfully that the text is unambiguous. Sex sex. That's what it is. And because of is what it is. So in the mind of a textualist, the preceding or proceeding history regarding statutory, these amendments and everything, it doesn't really make a difference because the text is the law. That is what you're supposed to go by. It's not the actions of congressmen down the line trying to add any amendments or anything. So from a textualist point of view, it might influence a little bit, but it should not be a binding factor. I'd be interested to see what other ones have to say.
Professor Atwood, do you have anything to add?
I totally agree with Nate's analysis, but Justice Gorsuch points out that it's speculative why Congress would refuse to enact these bills. And in fact, maybe some people said we don't need that. The statute already extends to sexual orientation and transgender status discrimination. But he says for all the reasons that we get nervous when we try to figure out legislative intent, that's multiplied when we're trying to interpret words enacted in 1964 based on congressional actions over the decades following that we can't really, it doesn't really shed light on what was intended at that time. And he says, as Nate is saying, what was intended, we don't even get to that because we think the plain meaning of the statute is clear.
Professor Antonini, would you like to add anything?
That basically covered most of what I would have said. I will just add that, there is the argument that Congress can always come in and correct the interpretation of the Supreme Court, just like they did in Gilbert, right? When the Supreme Court held that pregnancy wasn't covered, Congress acted and passed the Pregnancy Discrimination Act, specifically including pregnancy as being encompassed by because of sex. Now, again, what's interesting there is that that Congress stepped in to expand what sex meant. So again, there's an argument there that in the statute, sex could have potentially been already understood to encompass or to be a very broad rubric under which numerous things could fit under.
It's 12:58. I think we have time for one more question, and I'd like each panelist to weigh in on this very quickly so we can wrap up at 1 o'clock as we've promised to do. This final question comes from Professor Ellen Bublick, who asks, if you had written the opinion, is there anything else that you think should have been added or addressed differently? We will start with Professor Antonini, and then maybe Professor Atwood can weigh in, and we'll give Nate the final word.
That's a really fantastic question. And it's a very hard question. I'll start, I guess, just by comparing this decision to the decisions that have already been issued in the realm of same-sex rights, which have been generally given to us in the last few years by Justice Kennedy. So Justice Kennedy was the author of Romer versus Evans, Lawrence versus Texas, U.S. versus Windsor, Obergefell most recently. And you can see that in Kennedy's opinions, there is an appeal, which is easy to criticize, but this appeal to these ideas and ideals of dignity and harm. And the opinions of Justice Kennedy have been critiqued in part because of being hard to apply their directives by lower courts. How do you apply the idea that marriage responds to the universal fear of calling out and having no one there? But what Kennedy did really well was explain the harms that stem from discrimination. And any account of those harms are entirely missing from Justice Gorsuch's very strict literal interpretation of the statute. So I think having a more robust definition of the harms experienced by discrimination would have been something that I would have liked to have seen more clearly, especially given, the future issues that might arise in terms of balancing something like religious freedom and the free exercise of religion vis-a-vis anti-discrimination. Right now, the way that the opinion is written in Bostock, it's not clear what the real harms are. It's a very thin opinion on that. So if you balance these two competing concerns, it might be that the values associated with anti-discrimination come out wanting. So that would have been my amendment.
Thank you. Professor Atwood?
I totally agree with Albertina's concerns about the absence. What is missing from the opinion is really the meaning of equality. It's very dry, and his commitment to textualism, and I think his determination to avoid being viewed as importing social values or norms right now. He goes out of his way, and therefore the true import of it as bringing employment discrimination law to these populations, to gay and transgender people, the meaning, the huge meaning of that is sort of lost. It doesn't come through, and that then when he's at the very end of the opinion, as Albertina was mentioning earlier, when he refers to the Religious Freedom Restoration Act as a super statute that will essentially trump other federal laws, that's a very chilling reminder of his commitment to religious freedom, because equality doesn't really play any role in his opinion.
Thank you very much. Nate, we'll give you the final word.
Yeah, so I mean, I don't have too much more to add. I think Professors Atwood and Yancini really hit the high points of what I would look for as well. For me, just going back to religion and other kind of statutes that have this exact meaning, I understand he's confined to interpreting just Title VII, but it's a punt for a lot of the other stuff, which rightfully so. I mean, that's what the court does a lot, to kind of see how the lower courts work it out. I just would have personally liked to see a little bit more guidance on the religion and the RFRA, kind of counter arguments a bit. But again, those are an issue for another time. That's where I just find the least satisfaction was, I want more clarity on it, but I understand why there isn't. And I'm just really interested to see how it works its way through, and just really excited to see the positive ramifications that could come from this. So yeah.
Well, I'd like to thank all of our panelists and to thank all of you for being with us here today in this episode of LawCats Live. We're really glad you could join us and hope you enjoyed the presentations. That brings us to the end of our time. We still have a few questions, which I'm sorry we were unable to get to, but all of the panelists have told me that they are happy to stick around for about 15 additional minutes, maybe about 12 additional minutes at this point until 1:15, and to talk more informally with anyone who has time to stick around. But in the meantime, we thank you again for joining us, and just offer a brief reminder that there are additional sessions of LawCats Live, additional episodes that will take place in the coming weeks. And so we urge you to check the master calendar to see what those upcoming events are. And again, the panelists are happy to stick around for another few minutes here, and we'll get to some additional questions during that time. Our next question is related to family law, which of course is the core area of expertise of two of our panelists, Professor Atwood and Professor Antonini. And this questioner asks or observes that it seems like same-sex adoption is a subject of attack in some states. Do you see this case as having any implications for that issue? Professor Atwood, do you want to take the first crack at this question?
Sure. Let me think about that. I don't. I'm not sure I see any direct implications for it. The whole world of same-sex adoption has changed dramatically since the Obergefell decision, which in most states, joint adoption is unattainable except for a married couple for reasons that are, I think, understandable, wanting stability for the child, et cetera. And so once same-sex marriage was recognized throughout the United States, same-sex adoption by married same-sex couples is available. And so to the extent that the questioner is asking about same-sex adoption by unmarried couples, I don't know that this case would have any direct implications for that. It's already, it's loaded with family law policies that don't really relate to this to the employment context. But maybe my family law colleague, Professor Antonini, has some other insights on that.
No, I think it's an interesting question, and I too, given like the policy that's taken adoption, I mean, there might be a general way in which understanding discrimination on the basis of sex to include transgender individuals and also sexual orientation might be a way of, you know, potentially seeing different types of families as available to adoption. But I also think what happens in adoption too is like very low level discrimination. Like even if there are a number of different individuals available to adopt, you also see families themselves choosing generally, for instance, married couples who are relatively traditional in their makeup to, let's say, single individuals. So a lot of this doesn't necessarily track the sexual orientation, sexual identity discrimination, but more you know, a traditional family structure, whatever that might look like, versus single individuals.
Just to chime in, I mean, I could be wrong. I think what maybe they can send a follow-up question or something, but they might be referring to the case that's pending before the Supreme Court. Is it Sister of the Poor? Is that what it is? Does that sound familiar to anyone? It's this case out of the Third Circuit where an adoption agency was denying adoption opportunities for a gay couple, but I believe the adoption agency was not a state agency. It's a religious agency. So that might be what the attendee is asking about. And again, that is another question. I think it's more of a religious freedom, free exercise, RFRA argument. So that might be what they're referencing. But I will be interested to see how it comes up. And also, well, yeah, I'll leave it at that.
No, let me just jump in. That probably is right. I mean, that's a very closely watched case, and it will present this question of how far religious freedom can go in a state that had an anti-discrimination policy regarding adoption and foster care. And this case might have some relevance. I worry that the religious freedom argument is the one that's going to be, I mean, it will be central to that case. And it's going to be a question about the extent to which imposing anti-discrimination law would substantially burden the religious freedom of that entity, that adoption agency, which of course is a dimension that Justice Gorsuch doesn't get into in this case.
Right, and I will also say that it might raise issues of like the standard of review that we use to scrutinize discrimination against sexual orientation or gender identity. This is something that might be more of an open question now. If, you know, discrimination based on success is understood to include gender identity and sexual orientation, then maybe it will also be subject to heightened scrutiny, which is a higher standard of scrutiny. It's not quite strict scrutiny, which is applied to things like racial classifications, but it is a more searching scrutiny. And I will say that while that sounds like a positive, it may be positive in a lot of ways. There's also a downside in that when something is subject to heightened scrutiny, that also means that sometimes attempts to help that particular group will also be subject to a more rigorous standard, which means that attempts to help certain groups can also be now held to be unconstitutional.
That is our final question. So thank you to all of the panelists for this wonderful presentation and discussion. I've enjoyed it very much. And thanks again to all of those of you who have joined us here today. That's all we have for this episode of LawCats Live.
Thank you.
Thank you, everyone.